E R Leon and then space Viloria.
Should be on your private account, Mr. Weeks.
Pardon me? Okay, that helps.
Page 27 of your docket. Oh, you don't? Sorry.
That doesn't help me. Michael Joseph, is that it? Oh, okay, I have it. And where is Mr. Main Jail? Thank you. Thomas Enrique Leon Viloria. Mr. Weeks is here on your behalf, so don't say anything about your case. First, I do find probable cause. And
Judge,
Mr. Weeks,
I have Mark Durkee from A1 Signature Bonds. He's willing to post the bond. He's present in the courtroom. In reference, I think I didn't see much of a history on Mr. Viloria. I'd be asking the court to give him a standard bond. I think it's $10,000.
State, you have a position on this case? Pardon? Okay. I'll set bond in the amount of $10,000 on count one. And no contact with Alexander Rene LeBron. You understand that?
Understand.
Okay.
Thank you very much, Your Honor.
Okay.
Thank you.
Thank you, Judge. Good seeing you.
You too. Anybody else, any other attorney here that has a case that I can call out of order? Pardon?
I said I saw the prosecutor over there, but I guess he stepped out for a moment. He
On
was
your
here before I
case?
No. He was
Okay.
here before me. I didn't want to skip him. Good morning, Judge.
Good morning.
George Odom on behalf of Mr. McLawrence, and I would like to call Mr. Frank Lukes, L-O-U-X. He is on. Give me 1
The
second.
page doesn't help me.
Uh-oh. I know it helps some others.
Which jail is Mr. Luke's in?
He's in North Broward, Your Honor. He's on page 12. Show Sunrise. It's an MO case. Sunrise, City of Sunrise, yeah. Thank you, though. See, you checking, looking after me.
Frank Luke.
Yes. Can you see us? We don't have video over there.
Can you see us?
No, I can't see you.
Okay, hang on. You should be able to see us.
It says no incoming video.
Now?
Nothing.
Okay. We'll call somebody. Mr. Looks, there's an attorney here. Can you hear me?
Yeah, I can hear you just fine.
Okay, there's an attorney here on your behalf.
Okay.
You're charged with a misdemeanor. Actually, a misdemeanor capias was issued for you. Looks like on the charge of
It's like no lodging.
no lodging on city-owned property. There's a $100 bond. I do find probable cause. Mr. Odom?
Judge, first we seek appointment to his case number 172167 MO48.
I'll appoint Mr. McLawrence on that case.
And is the court inclined to resolve this today?
I am. It would be 3 days in the Broward County Jail.
Mr. Lukes, did you hear the court's offer?
3 days for what, sir?
The court is offering 3 days in the Broward County Jail with, and I'm assuming the court will give him credit for the 1 day he's currently been in custody?
Yes.
With credit for...
Yeah, I've been in jail for longer than 3 days, sir.
Okay, you were in jail prior to the current pickup. You were in jail for the same incident.
Yeah, I was in jail here.
This is an ad charge, so they didn't add it.
Oh, okay. I didn't know.
Okay, so what the court is saying that because this is an ad charge, the time you spent.
The 30th of May was when it looks like it was added.
Okay, so then the clock only starts once the actual charge has been, once you've been arrested on the charge.
Okay.
So then you would have the 1 day, but you would not count any previous time on a previous.
Right. So you're saying I have to do 3 days here?
And hold on 1 second, Mr. Lukes, and Judge, just so you and I are on the same page. It appears to me like I'm see the stamp for the ad charge, but it appears to me that the capias is a result from an older case. Am I?
Well, the capias did exist, but it appears that it was not served
Okay, so he wasn't
until
in custody.
the 30th. He may have been in custody on something else, but this case was
Okay,
not. This
okay.
capias was not served on him until May the 30th. So that would start the time on this case.
Okay, there we go. Okay, so
So the question is, does Mr. Lux want to resolve this case today?
Yeah, I want to resolve everything today.
Okay, well, this is one case you're here on. It's case number 17002167MO40A. You're charged with a municipal ordinance violation, no lodging on city-owned property. And your attorney is present here. If you'd like to resolve the case, you can do so. Is that what you'd like to do?
Yeah, I want to resolve.
I need you to raise your right hand, sir. You swear or affirm to tell me the truth?
Yes,
You can put your hand down. Would you state your full legal name?
Frank Luce.
Mr. Luce, you know that you do not have to do this today. You could have a trial on this case if you'd like to on another day. Would you like that?
No.
Okay. If you'd like to resolve the case today, then I have to ask you a couple of questions. Are you under the influence of any alcohol or drugs here this morning that would affect your ability to understand what you're doing?
No.
Okay, so how would you like to plead, sir, to no lodging on city property? Guilty or no contest?
Guilty. Right?
Okay.
No, same, right? Same thing?
It's up to you, sir. How would you like to plead? Guilty or no contest?
Guilty.
Okay. I'll accept your plea of guilty. I'll find that you're alert and intelligent, that you're here with an attorney with whom you say you're satisfied this morning and whose advice has indicated that you'd like to enter a plea today to this charge. I'm going to adjudicate you guilty, and I'm going to sentence you to 3 days in the Broward County Jail, and I'm going to give you credit for any time you have served on this case. You understand?
Yeah, do I have any other cases pending?
This is the only one in front of me this morning, sir.
All right.
Thank you.
Thank you, Judge.
Anything else, Mr. Odom?
Not to my knowledge.
Would you like me to call your case out of order, Mr. Lewis? Okay. Yes. Is it locked? Yeah, there's. Let me know if it's unlocked.
There you go. That. Did it unlock? Yeah. Okay. Thank you.
Jamara Davis. Where's Miss Davis?
She's in she's in
Paul
Ryan, Judge.
Jamara Janae Davis.
Paul Ryan, you on it?
Yes, can you see us?
Yes.
Yes.
Okay. Is this Miss Davis?
Yes.
Good morning, Miss Davis. You're here charged with touch or strike battery, domestic violence. I do find probable cause. Does the state wish to be heard on bond?
Yes.
No priors?
Judge, based on the nature of the allegation, in my speaking with Ms. Davis, she's been living here for 26 years. As she says, she's never been in trouble before. She does not stay with her mother. She actually stays with her aunt. Her mom has moved out of that apartment, so she will have no contact with her mother while this case is pending.
Okay.
And I would ask the court to consider pretrial release.
Okay. I'm going to release you on your own recognizance. I'm going to order that you call pretrial release 3 times per week. I'm going to release you on your own recognizance. I'm going to order you have no contact with Rhonda Davis while this case is pending. You understand?
Yes.
Okay. I do find probable cause. Daniel Rivera Huertas
Mr. Rivera Huertas is your president at Maine?
at the main jail.
Correct.
Good morning, Mr. Rivera Huertas. You're charged with touch, strike, battery, domestic violence. I do find probable cause. Any priors? No priors?
Judge,
What's the status with his mother?
my understanding, Judge, is the alleged victim is his mother. He'll be living separate and apart. He does live with her. However, he's going to be moving out living with friends, so he'll have no contact with her while the pendency of this case. As you heard, I believe this is his first arrest ever. He is a registered voter. He is working. He works at Zinburger as a cook, making only $10.50.
Okay, I'm going to release Mr. Rivera on his own recognizance. Going to be supervised by pretrial release. Call into pretrial release one time per week.
Yes, Your Honor.
And you have no contact with Luz Milagros Huertas Carrera. You understand?
Yes, Your Honor.
No contact means no contact, direct or indirect. You understand that?
Yes.
Okay.
Okay, here's the map to pretrial. Once soon as you get released, walk over. Just cross the street, okay? Good luck.
Omari Phipps.
Mr. Phipps, come on up, please.
Mr. Phipps, you're charged with touch, strike, battery, domestic violence. I do find probable cause. Yes, on case number 1, does the defense wish to be heard?
Yes, Judge. In reference to his pending case, Your Honor, I'd ask you at this time not to take any sort of action on it, but if Your Honor does revoke any sort of the bond conditions on that case, we'd ask you to consider the least alternative way, potentially pretrial release, maybe some sort of stricter level of release. I'd ask you also to impose on this charge $1,500 bond. The alleged victim is his sister, who's 20 years old. He's going to be living separate and apart from her with his friends that reside in the community. He's hoping his girlfriend will help post his bond. He works only part-time as a handyman, only making $200 per week. So that the $1,500 bond is going to be a stretch for him and his girlfriend. But that's what we'd be asking you to do at this time, Judge.
Okay, I do find probable cause on this case. I will set bond in the amount of $1,500. I am going to revoke his bond on case number 160090663CF10A, a case that he's currently out on bond on with Judge Bailey. He can see Judge Bailey regarding his status on that case.
Thank you, Judge.
So, State, I need you to prepare an order, if you would, please, on that. Jesus Enrique Araujo.
Mr. Araujo is here present, Judge, at Maine. Morning.
Good morning, Mr. Araujo. You're charged with touch, strike, battery, domestic violence. I do find probable cause on your case. State, any priors? No priors. Defense?
Judge, we'd be asking you to consider an ROR pretrial. This is his first arrest. He's a registered voter. He works for St. Bonaventure Church in their maintenance department. He's been working for that church for about 11 years now. Him and his wife are in the middle of getting a divorce. He's actually moved out. He has his own place in Plantation. Judge, he's been residing in our community for 15 years. Considering his strong ties to the community, his only time in trouble, we'd be asking you to consider ROR standard pretrial.
I'm going to set bond in the amount of $1,000. I'm going to order that he have no contact with the alleged victim in this case, Stephanie Ann Araujo. Understand, sir?
Yes, ma'am. Thank you, Judge.
Anthony Jennings.
Mr. Jennings is here present, Judge, at Maine.
Mr. Jennings, you're charged with touch or strike, battery, domestic violence. I do find probable cause. Any priors? Okay. I'm going to set bond in the amount of $500. I'm going to order no contact with the alleged victim in this case, Kalia Anaya Jackson. You understand, sir?
Yes, ma'am.
No contact at all, okay?
Yes, ma'am.
Okay. Pardon? $500. I do find probable cause. Lawrence John Gall.
Mr. Gall is approaching.
Mr. Gall, you charged with touch or strike, battery, domestic violence. I do find probable cause, state. Pardon? Defense?
Judge, I didn't hear what fire was read off.
He has a 2001 DUI according to the state. Do you have any information on the victim in this case who was transported to the hospital? Okay.
Judge, what
Yeah.
we'd be asking you to consider, I'm sorry.
Go ahead.
What we'd be asking you to consider on Mr. Gall's behalf is a $1,000 bond. As you heard, his prior offense was in 2001, so it's been 10 years. He is semi-retired. He was working at a gas station all his life. Unfortunately, he suffered from an car accident, so his monthly income is about $1,500 from the accident. He's 53 years old, been living here his whole life, and that's why we'd be asking you to consider $1,500 on his behalf. As I said earlier, he knows the alleged victim is he'll be living separate and apart, so therefore he knows not to have any contact or independency of this case, Judge.
Okay. I'll set bond in the amount of $1,500. I'm going to order no contact with Richard Joseph Heron. Mr. Gall's address is listed as that same address, so you have a different address you're going to be living at, sir?
Right now, Judge, he's actually going to contact his friends and see which friend will allow him to stay.
Okay, Mr. Gall, it's your responsibility to stay in touch and know when your next court date is, because the notice is going to go to the wrong address. You understand you're to have no contact with the alleged victim in this case? None whatsoever, direct or indirect. You understand that?
Yes, ma'am.
Okay, $1,500 bond. Can I help you, Mr. Ayers? Oh, that's not Mr. Ayers, sorry. I have Shane Raspberry.
North Broward, Your Honor.
North Broward, can you see us?
No. No, ma'am.
Want me to come back to Mr. Raspberry when you can see us? Or do you want to just hear us, Mr. Raspberry?
We could talk. We could do it, yeah.
Okay, Mr. Raspberry, you're charged with touch or strike battery, domestic violence. Don't say anything about the facts of your case. I do find probable cause. The state have anything with regard to priors?
No.
Don't say anything, Mr. Raspberry.
Oh, I thought, okay, sorry.
2007, he was convicted for possession with intent to deliver. 2008, conviction resisting officer without violence in 2012. Conviction for operating while revoked. Those priors are all
Wisconsin? Yes, Your Honor. Okay. I do find probable cause. I'm going to set bond in the amount of $2,500. No
Judge-
contact with Jade Renee Williams. You understand that, sir?
Yes.
No contact means direct or indirect.
Your Honor, I understand the court's found probable cause in Mr. Raspberry's case. I would just point out that the victim described the activity as Mr. Raspberry roughed her up, but she was not any more specific as to exactly what that meant. As you can see, Mr. Raspberry has sustained some injuries himself, apparently self-inflicted injuries, looking at the probable cause affidavit. He indicates to me that he does have some property, that he can provide money for his own bond. He is anxious to get out of custody so he can receive appropriate medical attention for his hand, which I believe he told me is going to need surgery. He would be staying with his father. I think his priors are all 9-10 years ago, so he has not been in any contact with law enforcement in that period of time. He works as an electrical technician at a company called Eaton, and he's had that job for about a year. I would ask the court to consider a $1,000 bond on Mr. Raspberry in light of all those factors.
Is his father in Wisconsin?
Yes, ma'am. But he indicates to me he will be retaining private counsel, and he will be coming back to South Florida to respond to these charges and whatever else needs to be done on this case.
Well, I do note the probable cause affidavit indicates he broke the window with his hand. and that he took her phone from her. He placed his hands on the upper part of her body. I know those are just allegations, but I do find probable cause, and I do set bond in the amount of $2,500. However, they have no contact with the alleged victim in this case.
Are you going to be able to make that bond, Mr. Raspberry?
I have about $1,500 in my name, and I have no one else to call. I mean, I'm trying to get I just had surgery a couple days ago on my hand, and I'm not getting proper medical treatment, and I am trying to get a lawyer to basically take this all the way because
Mr. Raspberry, don't say anything about your
Yeah,
case.
don't talk about the facts.
Okay, the bond is $2,500. You need to do what you can to try to post that bond, okay? Servio Espelitavez.
Conti,
Servio Espelitavez.
Conti, Your Honor.
Okay, can you see us?
Yes, ma'am.
Okay, you're charged with touch or strike domestic violence. You're also charged with resisting or obstructing without violence. State. With who? Okay. Do you have the case number?
Yes, Your Honor. Case number 16-01-0070.
Okay, I do find probable cause on touch, strike, domestic violence, count 1. Just get set bond in the amount of $2,500. On count 2, resisting an officer without violence, set bond in the amount of $1,500.
Your Honor, in my conversations with Servio, he has been living here in Florida for the last 10 years. He has family here, including his mother and his father. He will not have any contact with the victim in the case. He's been working the same construction job for the last 2 years. He also has a second job at McDonald's. He's provided me with the name of his mother and his other brother, and I'll be contacting them, but he indicated to me that they're probably going to be able to come up with a bond somewhere in the area of $1,000, that they might not be able to make a $2,500 bond. I would ask the court to consider a $1,000 bond on Servio's case.
Mr. Reedy, he's lucky that there's not a probation hold on him right now. He's on probation with Judge
I'm aware of
McHugh
that, Judge.
on looks like a domestic violence misdemeanor case. So I'm going to set bond in the amount of $2,500 on count 1, $1,500 on count 2. I'm going to order you have no contact with Francisco Javier Espaillat. This also happened at his mother's residence, so I'm not going to order no contact with her, but I am going to order no contact with your brother. You understand, sir?
Yes, ma'am.
Okay. John Galashaw.
That's in North Broward, Judge.
Thank you. Mr. Galashaw,
Yes, Your Honor.
you're here this morning on aggravated battery with a deadly weapon, domestic violence.
Yes.
Don't say anything about your case, please, sir, okay?
Okay.
Any priors on Mr. Galashaw? Galashaw, yes.
Okay, he has priors off the state of Pennsylvania, Your Honor. Conditions appear to be unknown. 1991, he was arrested for burglary, criminal trespass, criminal assault, interfering with child
Thank you. Defense?
Your Honor, I don't think Mr. Galashaw is going to be able to post any kind of bond, quite frankly. As the court noticed in the probable cause affidavit, this happened in a living facility. He doesn't have any money. He receives disability. He's been receiving disability since 1993, approximately $733 a month. He doesn't have any friends or family for me to notify, so I advise Mr. Galashaw he might have to stick it out.
Okay. I do find probable cause as to aggravated battery with a deadly weapon. I'm going to set bond in the amount of $20,000. No contact with Christopher Taravella. You understand, sir?
Yes.
Okay. Robert Jerome Faircloth.
Mr. Faircloth here, present, Judge of Maine.
Mr. Faircloth, you're charged with aggravated assault with a deadly weapon, domestic violence. You're also charged with touch or strike battery, domestic violence. I do find probable cause as to each of those counts. Can anybody give me any information on his priors? Defense?
Judge, we didn't hear anything as far as his priors.
2008 extortion.
Okay. Judge, as you're it's been 10 years since his last contact with the criminal justice system. He's 29 years old, been residing here his whole life. He was working for a company doing air conditioning. Unfortunately, he lost his job, and now he's currently looking for work. He will be living separate from the alleged victim. He'll be residing with his mother, who lives in Sunrise. The only potential person that can help him with bond is his mother, but she works 3 jobs just to pay the bills, so financially he's not in position. What he's asking judges for you to consider, if you consider pre-trial release with a level 2, which would allow him to go to and from work and to look for work. That's what he'd be requesting. And the alternative, Judge, we'd be then asking you to consider a $1,000 bond on count 2 and a $1,500 bond on count 1.
Okay, on count 1, I'm going to set bond in the amount of $2,500. On count 2, I'm going to set bond in the amount of $1,500. I'm going to order no contact with Lynn Brown. You understand that, sir?
Yes, ma'am.
Okay, the address that you listed on your arrest sheet is the same address as her, so you need to make sure that you, if you do bond out, notify the clerk of any change of address. You understand?
Yes, ma'am.
Can I help anybody over here? Private attorneys? Which one are you on? Is she here? I put a note on the, if she comes in, we'll give you a call, okay? That was the one that was scheduled for this morning. We put a note on the door. She's in the MDP program. No, it's not going to be completed till June, but I do have that. So if you just want to check back with us, we're fine for now. Okay? Okay, you can just check back with us. Okay.
Good morning, Judge. How are you?
Good morning, Mr. Weinstein.
Michael Weinstein. I'm here on behalf of Jock Sadie. Your Honor, I was called late yesterday and then confirmed it again this morning that his friends wanted me to appear on his behalf. I did call your JA and said I'd be here about 9:15-ish, 9:20, so I made it.
Age 19, Hector.
On behalf of the state of Florida.
Do you know which facility he's in?
North Broward.
Okay, we're having difficulty with North Broward this morning. Is Mr. Sadie there, please?
Okay, we got.
I'm here, Your Honor.
Can you see us or not?
No, man, but the audio is good.
Jack, can you hear me? It's Michael Weinstein. I'm here for you.
Hi, Mr. Weinstein.
How you been?
Don't say anything about your case, Mr. Sadie.
Yes, ma'am.
You have an attorney here for you. Let me just find the paperwork. Okay, Mr. Sadie, you're charged with driving while license suspended with death or serious bodily injury. You're also charged with careless driving and no proof of insurance. Mr. Lewis?
Yes, Your Honor. Derek Lewis on behalf of the State of Florida Traffic Homicide Unit. Just so you know, I actually have the detectives from Fort Lauderdale who are working the case. They're present in court if you have any questions for them.
Good morning.
The victim is still in a coma since the date of the crash. We're trying to find his family, obviously, to talk to them and see what's going on. But the one contact we do have lives out of state. Otherwise, we would have made contact and they'd be here today. We'd be asking the court for a $60,000 bond. We'd be asking the court to order no driving, no alcohol or intoxicants, random testing, and also that he forfeit his passport. He's not a citizen of the United States. Just by way of a little bit of introduction, he does have a prior DUI and a no valid driver's license charge. That's from a couple years back. He recently went through a pretrial intervention program for a delivery of cocaine charge that he just completed, and it was pretty soon before this crash. And that's what we're taking into account by asking you for the amount that we did.
Mr. Weinstein.
Judge, as you can see, Mr. Sadie was incredibly injured in this particular accident. Yes, he is not a citizen of the United States. However, he's got ties to the community. He's been here for 6 years. He's here legally. He's here on a valid work visa. He does work in the yachting industry. I don't have a big problem with the state's request to surrender the passport, but $60,000 bond, based upon what his friends have told me, he's working, as a yachty, paycheck to paycheck. So I don't know that he's going to be able to even come close to a $60,000 bond. I was aware of the drug charge. That's how I first met Mr. Sadie. I don't think it was serious, but it was more of a personal use thing than it was a delivery thing, from my understanding. I do understand he had the DUI several years ago. That is something that I understand the court's going to take into consideration. $60,000 bond is tantamount to no bond. I'll point out, as serious as this case is, and it is extremely serious, this is him driving recklessly, causing significant injuries. However, it wasn't like he went to 7-Eleven and robbed someone. He did something. I think the court gets my gist.
Okay.
I would just ask the court to consider a much lower bond, but other than that, whatever restrictions you feel necessary.
Okay. I'm going to set bond in the amount of $30,000. I'm also going to order that he be supervised by pretrial release with a GPS monitor, that he surrender his passport, no driving as a condition of the release, no alcohol. The TAD monitor would be fine, yes. Yes, he needs to get his passport to his attorney, and his attorney can surrender it to the clerk of court before his release. No driving and no alcohol. I do find probable cause as to each count. Anything else?
No, Judge.
No, Your Honor.
Okay.
All right, Jack, we'll be in touch.
Thank you.
Have you ever seen my handwriting? I can write it. It's fine. Brian, I'm going to...
Jean-Piero Guadagno.
Judge, he's in Maine. We're going to require a Spanish interpreter.
Okay. We'll call for one now, okay? Moneshwar Hanuman.
Judge, he's approaching the Defense Service Public Center. He has private counsel.
He has private counsel?
Correct.
Who's your attorney, sir?
My friend is supposed to get Robert something. I don't know his last name.
Okay, you're here this morning. You're charged with touch, strike, battery, domestic violence. You're also charged with kidnapping, count 2 and count 3. You're also charged with false imprisonment, counts 4 and count 5. On count 1, the state wish to be heard?
Yes, Your Honor. Apparently, there's only one kidnapping and one false imprisonment, as opposed to 2 in the booking sheet. And if the court's inclined to set a bond, we'd ask for the standard bond, notwithstanding the potential penalty of first degree punishable by life. We've been in contact with the victim in this case.
You have or have not?
Have.
Okay. I'm seeing on the probable cause determination sheet there are 5 counts. You're saying there aren't? Because he was booked
No.
in. He was
Counts
booked.
3 and 5 apparently are duplicitous of 2 and 4.
Nevertheless, he was booked on those.
Well, if you're inclined to set a bond, you could set a bond of $0 for those
Well,
2 counts.
On counts 2 and 3, I do find probable. I do find probable cause, and based on the case law, I find that the proof is evident and the presumption is great, and I'm going to hold him no bond on counts 2 and 3. He can see his judge, who's the case is assigned to for a bond hearing on that matter. On count 1, I'm going to set bond in the amount of $2,500. On counts 4 and 5, I'm going to set bond in the amount of $5,000 on each count. I do find probable cause as to each count, and I'm ordering that as a condition of any bond, if he makes bond at a future date, that he have no contact whatsoever with Gaithry Davi Sohit. Do you understand, sir?
Yes, ma'am.
Don't say anything about your case. If you have an attorney, you need to get in touch with your attorney. Okay?
No, my wife is in the court, ma'am. And my son is there.
I don't see your wife in the court here today.
Oh, she's not there?
I don't see anyone here.
Yeah, they're supposed to be here, ma'am.
Okay. So you'll need to call your attorney, sir.
Okay, thank you.
Althea Josephs. Althea Josephs in the main?
I'm being told to reset it, Judge.
Reset to,
Confinement status took her off.
pardon me?
Deputies advised me that confinement status took her off the docket.
Okay, why's that?
There should be a representative there from confinement status that could enlighten us.
Okay, maybe you could let us know. Althea Josephs. Pardon? They're verifying her identity? So will they be bringing her back at 1:30? Okay, hopeful at 1:30.
Okay, reset the cam.
Richard Maldonado.
Mr. Maldonado, come on up, please.
Mr. Maldonado, you're here on an out-of-state hold on a felony warrant from New York. I do find probable cause. There's no bond on that. Regina Jenkins.
She's in North Broward, Your Honor.
Okay. Regina Jenkins.
Well, now we can't see them either. Here we go.
Regina Jenkins.
That's us, North Broward.
North Broward. Can you see us now?
Yeah, but I still got.
Okay. Miss Jenkins, you're here on 2 separate capiases or warrants on, actually on one case. There's 2 separate warrants. One bond is the amount of $500 and one bond is the amount of $250. It's Judge Fishman. I do find probable cause.
Ms. Jenkins had indicated to me, Your Honor, she might be interested in resolving these cases today.
Does the state have any recommendation on this? Charged with possession of cannabis.
That'd be fine, Your Honor.
Pardon?
That'd be fine to resolve it.
Okay. Do you have any priors?
Doesn't show anything, Your Honor.
No. Ms. Jenkins, if you'd like to resolve these cases today?
Yes, ma'am.
On count 1, possession of cannabis, I would withhold adjudication of guilt, impose $293 in court costs. On count 2, operating without a valid driver's license, I'd adjudicate you guilty and waive any additional cost.
Okay.
Would you like to do that?
Yes, ma'am.
Are you guys representing her?
Yes, we are, Judge.
Okay, there's an attorney here in the courtroom, Miss Jenkins. Do you have anything you'd like to ask him before we go forward?
No, ma'am.
Okay, you understand that you have a right to have a trial on these charges if you'd like to.
No, ma'am.
If you enter a plea today, the case will be resolved and over with. You understand that?
Yes, ma'am.
Okay, I do find that there is a sufficient factual basis to accept your plea. Are you under the influence of any alcohol or drugs here this morning?
No, ma'am.
Okay, how'd you like to plead to one count of possession of cannabis, guilty or no contest?
No contest.
And how would you like to plead to operating without a valid license?
Guilty.
Okay, I'll accept your pleas. I'll find that you're alert, that you're intelligent, you understand the nature of the charges against you and the consequences. On count one, I'm going to withhold adjudication of guilt, impose $293 in court costs, give you 6 months to pay that court cost. On operating without a valid license, I'm going to adjudicate you guilty and give you credit for time served. You understand?
Yes, ma'am.
Okay. Okay, good luck to you, ma'am.
All right.
Latoya Morris. The main jail? Oh. So what do we do? They're calling for us? Is Miss Morris in the main jail? Okay. Okay. Okay, thank you very much. Sophia Maria Garcia.
Court for hours, Your Honor.
Can you see us, Miss Garcia?
Yes, ma'am.
Okay, don't say anything about your case. You're here on a ad charge, capious felony on charging you this morning. You're on one count of possession of a firearm by a convicted felon. That's Judge Bailey, Tim Bailey's case. It's a second-degree felony. State wish to be heard. My understanding she's being held no bond on a robbery firearm as part of this case.
No, Your Honor.
Okay. Defense?
As Ms. Garcia and I discussed earlier, she knows that she is not going anyplace because of the no bond hold. So I'd ask the court for a nominal bond on count 5.
I'm going to set a bond in the amount of $15,000 on this case. I do find probable cause.
If the court wants, you could call on the next, or that would be page 9. On page 10, there are 2 people.
They say they're
in
back
line.
up at the main jail. Let's give them a try.
Are we back?
Are you there? Latoya Morris. Can you see us there?
Hello? Hello?
Can you see us or hear us?
We can see you, but we can hardly hear you.
Okay.
We have Miss Look. Incoming call.
How's that
We
now?
can see you again.
Can you hear us now?
Faintly.
Any better?
I wish there was a volume control. You could just
There is a volume control here. It's all the way up.
The tech man. Where's the Sue? Do you know the tech person's phone number to call him?
He was just here.
Yeah, because we can't hear.
Okay, we'll come back to you. We'll come back to you, okay? Who's the next one we could call, Mr. Reedy?
If you want to contact the Paul Ryan facility, we have April Campbell.
April Campbell.
Paul Ryan facility, Your Honor.
Can you hear and see us?
Yes, ma'am.
Okay. Ms. Campbell, you're here charged with aggravated assault with a deadly weapon without intent to kill. You're also charged with burglary of a dwelling or conveyance armed. Criminal mischief over $1,000. Capious on a felony. and a warrant for violation of pretrial release. I do find probable cause. The capias is with Judge Tobin Singer. Those are no bond holds from Judge Tobin Singer. On count 2, I do find probable cause, and I do find that the proof is evident and the presumption is great. There'll be no bond on that. You'll have to see the judge who's handling this case. On count 1, I'm going to set bond in the amount of $10,000. And bond is set on count 3 in the amount of $500.
In light of the fact that Ms. Campbell has a no bond hold on counts 4, 5, and 6, the defense will not be making any arguments regarding the proof evident presumption great at this time.
Okay, thank you, Mr. Reedy. Pardon? No contact whatsoever with the alleged victim in this case. You understand that, Mrs. Campbell?
Yes.
That's Howard George Stiles.
Yes.
Count what? 2? Count 6. Okay.
I'm sorry, which count?
Count 6. It's right, I understand. Okay, who else can we call in that? Lavinia Brown.
Right here. Right here.
Okay, thank you very much. Lavinia Brown, you're here with violation of probation. It looks like you have a court date to see your judge on June the 5th at 9 o'clock. You're being held no bond on that violation of probation warrant. I do find probable cause.
Yes, sir.
Next case on the docket, Your Honor, also with Paul Ryan, is Vincinia Osborne.
Vincinia Osborne. Ms. Osborne, you're here today charged with grand theft auto, possession of cannabis 20 grams or less, and possession of fentanyl. Count 4 is probation violation or community control violation. That is no bond. You need to see your judge on June the 5th at 8:45. On count 1, your bond is set in the amount of $1,000. Count 2, $100, and count 3, $1,000. I do find probable cause as to all counts.
So
You'll need to see your judge on your violation of probation case.
that's it. So
Marie
I'm gonna drop.
Marie Barrow. That's the main jail.
Ain't even drop the other charges.
Yes, Judge, the
Last name is spelled? Carrie Dwab. And that's, you said North Broward? Carrie Dwab.
Here you go.
Mr. Dwab, you're here this morning for a violation of community control. Judge Merrigan, there's a warrant. You're being held no bond on that. You need to see Judge Merrigan on June the 20th at 8:45 in the morning. I do find probable cause. Any others? Everything else is the main jail? Do you have any more there at North Broward?
I think he's waiting on his attorney. No, he's not.
There are some municipal ordinance cases, Judge, that I
Okay.
didn't list because I wasn't going to be able to represent them.
Okay.
There's Daniel Diaz, who I suspect is that gentleman at Rhine.
Daniel Diaz is at Paul Ryan.
Yes, ma'am.
Mr. Diaz?
Yes, ma'am.
Good morning. You're here today on two separate cases. Actually, it's one case, 2 counts of municipal ordinance violation. There was a capias or warrant issued for your arrest for failure to appear, trespass on private property, and trespass on private property. I do find probable cause. There's a bond in the amount of $100 on each of those cases. These are the City of Hollywood Would you like to resolve these cases today?
Yes, ma'am. Yes, I would.
Okay, if you want to enter a plea today, my offer to you is going to be 5 days in the Broward County Jail with credit for any time you have.
I already have 45 days, ma'am.
On these cases?
Yes, I understand.
Okay, so you're charged with 2 counts of trespass. Are you under the, would you raise your right hand, sir?
Yes, ma'am.
You swear or affirm to tell me the truth?
Yes, ma'am.
Okay, you can put your hand down. Would you state your full legal name for me?
Daniel Diaz.
Mr. Diaz, you're here, as I said, on 2 separate counts of trespass. That's case number, 2 separate cases, 17002026 MO40A and 17002025 MO40A. Each count, you're charged with trespass. It's a violation of a municipal ordinance, punishable by up to 60 days in the county jail. You understand that?
Yes.
And you under the influence of any alcohol or drugs here this morning that would affect your ability to understand what we're doing?
No, ma'am.
Would you like to enter a plea this morning?
Yes, ma'am.
How would you like to plead, guilty or no contest?
No contest.
To each count.
Yes, ma'am. To each count, no contest.
Okay, I'll accept your plea of no contest as to each count. And as to each count, I will adjudicate you guilty and sentence you to 5 days in the Broward County Jail. Give you credit for any time you have served on these cases. Each case is concurrent with each other, and each of these cases is now concluded. You understand, sir?
Yes, ma'am.
Good luck.
Thank you.
Anybody else there at Paul Ryan?
No, Your Honor.
Thank you very much.
Is the next case on the docket Arthur Mitchell?
That's not Broward.
Arthur Mitchell?
Yes, ma'am.
Mr. Mitchell, you're here today on 2 separate capiases. Each of those cases is charging you with trespass on private property. Each of them occurred in the city of Hollywood, it looks like. Actually, these are municipal ordinance cases, which means that they're punishable by up to 60 days in the county jail. You understand that, Mr. Mitchell?
Yes, ma'am.
Would you like to resolve or end these cases today?
Your Honor, I would just state that Mr. Mitchell has a pending felony count. Count 1 is aggravated assault with a deadly weapon without the intent to kill. He has a $7,500 bond on that. So even if he were to resolve the municipal ordinance cases here this morning, he would still not be getting out unless he's able to post that bond.
You understand that, sir?
Uh-huh.
You have a bond of $7,500 on another case. The attorney that's here in the courtroom from the public defender's office has indicated that unless you're able to post that bond, you're likely not to get out of jail even if you resolve these cases. You understand?
Okay.
Would you like to resolve these, or would you like to see the judge who these cases are pending in front of?
Yes, I would like to see the judge because what happened?
Okay, I don't want you to talk about the, I don't want you to.
Don't tell us what happened, Mr. Mitchell.
I just don't want you to talk about the facts of your case, so I do find probable cause. Each of the case has a $100 bond on it, sir, okay? Good luck to you. How we doing there at the main jail?
Perfect. Now I hear you clearly.
Okay, I'm going to call an attorney out of turn if you just give me 1 minute.
No problem.
Good morning, Mr. Collins. How are you? Nice to see you. How can I help?
Moment of history in here. There's over 120 years of combined legal experiences right in this little neighborhood over here. Oh, more. I didn't even see. Quarter century, maybe. More. I mean, quarter of 1,000.
Who are you here on, Mr. Collins?
Judge, you already. I talked to Mr. Geisler. You've already called Hahnemann, Monashar Hahnemann.
Okay, did we already do it?
You did it, and unfortunately, when we came into the building, nobody knows where to send us on these things. And I went to the old wing, and the family went to another wing. And
do you know where he is? Is he in the? Right,
Yeah.
said his family was coming.
Yeah, and they're here.
Okay, just wait 1 second. Can we get Mr. Hahnemann back? Is that possible?
Mr. Hahn, was he at Maine, Judge?
He was at Maine. We already did it. His attorney is now present in the courtroom.
They're going to try and locate him right now, Judge.
Okay, we'll put it on recall then. If you guys can locate the paperwork too. Okay, we'll put it on recall. Thanks. LaToya Morris.
Ms. Morris is here present, Judge, at Maine. Judge, as a friend of the court, she did advise me she wishes to ask the court if you would consider resolving her case today for time served.
The problem with resolving that case today, Ms. Morris, is that I'm looking at your driving record. It indicates that you have a prior for driving on a suspended driver's license. I don't know if there are any other cases pending. So if you resolve it today, you face the possibility of your license being revoked for a period of 5 years. You understand there's a warrant for your failing to appear in court, and the bond is set at $500. Is your address the address in Pompano Beach the correct address?
Yes, ma'am.
Apartment 3?
Yes, ma'am.
Do you get mail at that address?
Yes, ma'am.
Okay, I'm going to release you on your own recognizance on this case. You're going to need to see the judge who's handling this case. You understand?
Yes, ma'am.
Do not miss court again or you'll find yourself right back in the same situation. You understand?
Yes, ma'am.
All right, I'm going to release her on her own recognizance. I do find probable cause.
Thank you, Judge.
Krista Nicole Jackson.
Judge, after Ms. Jackson, they already brought Mr. Hahnemann back.
Okay, thank you. Ms. Jackson is charged with grand theft auto, driving on a suspended or revoked driver's license, and there's a capias or a warrant on a criminal traffic case. Bond in count 1 is set at $1,000. Bond on the capias is $1,000. I do find probable cause. Total bond $2,000.
You'll be seeing your judge June 2nd at 9 a.m. Good luck.
Okay, now do we have the paperwork on Mr.? Thank you very much. Okay, Mr. Collins on Monswar Hanuman.
Your attorney's right there.
Mr. Hanuman, you're back on the record here. Can you see us?
Yes, ma'am.
Okay, your attorney, Mr. Collins, is here in court this morning. And also here is,
The complainant is here.
Okay.
The person's alleged victim on the case.
and,
His son, and then another family friend.
okay,
And you read the PC, Judge. Basically, the complainant contacted me. She is not afraid of him. She would like to have some kind of a bond. There's probably technically enough to find PC for. I think it's kind of overcharged. The false imprisonment part. They were married 20 years. They're separated now. They still have contact. And she has contacted me. I can just proffer to the court, and if you want to hear from her, she can
I
tell me
did find probable cause as to each count. And the problem is, Mr. Collins, in counts 2 and 3, the estate has alleged a kidnapping count. I did find probable cause, and I did find proof evident presumption great. Rather than having an Arthur hearing this morning, it's best if you set this with the judge who's handling the case.
Okay.
Rather than me having an Arthur hearing this morning, because then you're not going to be able to present what you may want to present to a judge.
Okay, it's Judge Cohen, but I just wanted to.
So I did find probable cause as to each count. I set bond in the amount of $2,500 on count 1 and $5,000 on the false imprisonment charge.
Okay, the kidnapping should have it should be. I mean, it's not an armed kidnapping. It should be a bond. It's bondable.
It's charged as a first punishable by life.
Oh, that's how they charge it.
Yeah.
I don't know why. How did you find? Did you read the probable cause affidavit with respect to that? How is the life?
The way they've charged it as a first punishable by life, they did allege kidnapping. So I did find probable cause as to the kidnapping.
Okay.
Okay. Mr. Hahnemann, your attorney's here, and he'll be working on your case, okay?
Okay, thank you, ma'am.
All righty.
Thanks, sir. Good to see you.
Marie Barrow.
Ms. Barrow is here, present Judge Amin. She's approaching.
Ms. Barrow, you're charged with grand theft. I do find probable cause. Bond is set in the amount of $1,000.
Judge, if the defense could be heard, and speaking Ms. Barrow, she's been residing in our community her whole entire life for 19 years. She's currently employed. She works at BurgerFi. She makes approximately $9 an hour. She lives in Tamarack. She lives with a roommate. The rent is about $1,000. Her portion is $500. She's right now saving up to start Broward College. She'll be starting this fall. She's a registered voter. My understanding is, Judge, that this is her first offense ever. She sometimes also attends Dorma Church, which is located in Tamarack. She's volunteering there. She works with their outreach program, providing information to the community as far as cancer, Judge. What we'd be asking you to consider at this time, considering her strong ties to community, Judge, is an ROR. This is a nonviolent offense. There is a presumption to be released on non-monetary conditions. That's what we'd be asking for, Judge, an ROR.
Does she have any priors? No, Your Honor. Okay. I will release her on her own recognizance. Pretrial release will, part.
She indicated that her previous address was University of South Florida, which is out of the Tri-County area. And also, I heard the PD indicated that she resides with a roommate.
Yes.
She informed pretrial that she resides alone.
She resides alone?
Alone. We were unable to verify whatever information she provided, Your Honor.
So pretrial was unable to verify the information that she provided.
She was attending UCF, was it UCF or USF? USF, Judge. Now, since then, she relocated down here to South Florida, and that's why now she's planning on enrolling in Broward College in fall of this semester. But she is living in Tamarack, and she lives there with a roommate at this time.
Who lives at that address in Tamarack?
Yeah.
No, I don't want the name of her roommate. I'm just saying, how long has she resided at that address in Tamarack, apartment 101?
She's been living at that apartment 101 in Tamarack. 3 months? Okay. I've been advised, Judge, 3 months.
Where's home for her?
Your Honor,
Where's home?
original place
Where's
of
home
birth
right
is
now?
Haiti. Length of time in the U.S. and in Florida,
Right,
Your
you
Honor, is
relocated.
not indicated. Contradictory information is being provided on record versus what was given to pretrial in person. She advised that pretrial that she resided at this address in Tamarack for the last 2 months. Now she's stating to the courts on record that she's been there 3 months.
Are you hearing this?
Judge, I thought I heard incorrectly initially from what I was advised by pretrial. Pretrial said that she advised that she was living in UCF. Now pretrial saying that she advised that she was living in Tamarack. So I'm hearing inconsistent
Okay,
statements
so
from pretrial.
I'm not going to have a back and forth between you and pretrial. I'm going to release her on her own recognizance. I'm going to order that she be supervised by pretrial release and that she call into pretrial release 3 times a week. And that if she moves from that address, that she needs to notify them immediately.
Yes, Judge. Thank you very much. This is the address. This is the location pretrial. As soon as you get out, you have to go.
Your Honor, our Spanish
Yes, sir.
interpreter is
Come on
here.
up. Good morning. If we could call Jean-Pierre Guadagno.
He's here present, Judge, I mean?
Okay, we have a interpreter here in the courtroom. Could you please raise your right hand, sir? You swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability.
I do, Your Honor. Igor Feliciani, F as in Frank, Elicioni.
Ms. Guadagno, Mr. Guadagno,
Señor Guarano,
you're charged with touch or strike battery domestic violence
usted está siendo acusado con un contacto o una agresión de violencia doméstica,
and false imprisonment of an adult.
Captura falsa de un adulto.
And I do find probable cause as to each of those counts.
Y hallo que hay causa probable para cada uno de esos cargos.
Can anybody give me any information on priors?
¿Alguien me puede dar información acerca de su récord historial previo?
Okay.
Su señoría, no veo historial previo.
In defense? Sorry?
And speaking with Mr. Guadagno, he's not...
I can't hear when everybody's talking. Sorry.
Oh, okay.
Aquí aparece que él tiene 0 meses de residencia.
Okay, the probable cause affidavit says he doesn't live here.
La declaración jurada de causa probable dice que no, él no vive aquí.
Defense?
Okay. Judge, I've been advised he's been residing here in South Florida for 5 years. He was a U.S. resident. He became a U.S. citizen, is what he advised me. He's 19 years old. He lives with his wife in Miramar. However, I've been advised that due to this incident, she's moved out. His father is hoping that he will be able to post his bond. He advised me this is his first contact with the criminal justice system. He is employed. He works at a car wash making $100 a day.
Su señoría, la persona el acusado me acaba de indicar que él es un residente del estado del sur de la Florida. Los últimos 5 años, él solía ser un residente de los Estados Unidos. Ahora se convirtió en un ciudadano. Él tiene 19 años, vive con su esposa Margaret. Ella, a causa de este incidente, ella se mudó. Su padre quiere poner la fianza. Es su primer contacto con el sistema judicial criminal.
Okay, as to count 1, I'm going to set bond in the amount of $1,500. As to count 2, I'm going to set bond in the amount of $1,500. I'm going to order that he have no contact with Karim Casas.
Con respecto al cargo número 1, voy a fijar la fianza en $1,500. El cargo número 2 va a ser una fianza de $1,500. Y voy a ordenar que no pueda tener ningún tipo de contacto con la señora Karen Casas.
Understand?
¿Entiende?
Sí.
Yes.
Okay. No contact means direct or indirect.
La orden de no contactar incluye contacto directo o indirecto.
So that means you can't have someone else contact her, you understand?
Eso significa que no puedes contactarla mediante un tercero. ¿Entiendes eso?
Sí.
Yes.
Okay, thank you.
Ok, gracias.
Can you make an announcement, see if there's anybody else?
¿Alguien más necesita intérprete español?
Español, ¿quién más habla español? There's one gentleman raising his hand. Judge.
Okay.
¿Qué es su nombre? Jorge. ¿Qué? Jorge Borges. Jorge Borges. Jorge Borges. Page 28, so towards the end.
We'd waive a formal reading of the allegations, Judge.
Vamos a renunciar a la lectura formal de los cargos.
Okay, Mr. Jorge Borges.
Señor Jorge Borges.
Yes.
You're here on a violation of probation case. There's a warrant. There's no bond on that case.
Usted está aquí por una violación de su probatoria. No hay no hay fianza en ese caso.
And there is a out-of-county hold on a misdemeanor case.
Y hay una orden de fuera del condado de retenerlo por una infracción, por un caso de una infracción.
It looks like you're going to see your judge on June 5th at 9 o'clock in the morning.
Usted se va a ver con su juez el día 5 de junio a las 9 de la mañana.
I do find probable cause.
Hay que hay causa probable.
¿Alguien más habla español? Español. No one else here in Maine requires Spanish interpretation.
Thank you very much. Thank you for coming. Appreciate your help.
No problem. If I could have the name of the previous person.
The name was Jorge Borges.
No.
No, the one before that.
Oh, was Gene
I have it, Brian.
Guadagno.
Gene what?
Guadagno.
Thank you. Thank you.
And we have Scott Mayberry.
He's approaching, Judge.
Mr. Mayberry, you're charged with trespassing on a property or not a structure or conveyance and a municipal city violation. Do you understand that? Is the public defender's office representing him?
We cannot, Judge. It's a municipal ordinance.
Pardon?
Oh, count 1 is not. We can represent him on count.
Count 1 is a trespass. Count 2 is a municipal ordinance, open container of alcohol. You representing him on count 1?
Yes, Judge.
Would you like to resolve the case?
And speaking Mr. Mayberry, Judge, yes, he does want to. He wishes to ask the court if you would consider giving him time served today.
My offer is going to be 10 days in the county jail if he wants to resolve it today.
Okay, I'll take it. Let the judge know that. Yes, ma'am, I'll take it.
Okay, you understand, Mr. Mayberry, that you don't need to enter a plea here today. If you'd like to see a judge on another day, you can do so and have a trial on this case if you'd like.
No, that'll be all right. I'll take the time.
Are you under the influence of any alcohol or drugs here this morning?
No, ma'am.
You understand what you're
Yeah.
doing?
Yes, ma'am.
You understand that you're charged with trespass? Is it charged as a first-degree misdemeanor? Let me see.
Yes, ma'am. Your Honor, I'd
Char-
like to give
Sir, there's an attorney standing right next to you. You might want to talk to him.
I want to
We're fine to proceed, Judge.
Okay. So, Mr. Mayberry, I asked you if you're under the influence of any alcohol or drugs here, or do you understand what you're doing here today?
Yes, ma'am.
Okay, so how would you like to plead to one count of trespass and one count of possession of an open container?
No contest.
Okay. I'll accept your plea of no contest. I'm going to sentence you to 10 days in the Broward County Jail. I'm going to give you credit for any time you have. And Mr. Mayberry, I'm going to direct that you not return to 4960 North Dixie Highway in Oakland Park. You understand that?
Yes, ma'am.
They don't want you at that location.
Yeah, I understand that.
Okay. Good luck to you.
Thank you.
Andre Mwangi.
Mr. Mwangi, come on up, please. Is here present, Judge?
Okay, Mr. Mwangi, you're charged with trespass and you're charged with a municipal ordinance violation, possession of an open container. You understand that?
Yes, I do.
If you'd like to resolve these cases today, the offer from me is 10 days in the Broward County Jail, or your bond is set in the amount of $25. This is a co-defendant of the previous gentleman.
Judge is offering you 10 days to resolve the case if you're pleading no contest, or if you wish to dispute the allegations and have your day in court, you could choose to bond out, which would be $25. It's up to you.
Okay, I'll resolve it today.
Okay, Mr. Mwangi, you understand you don't need to do that. If you'd like to see a judge on a different day, you're entitled to have a trial. You understand that?
Yes.
But by resolving the case today, the case will be over. You understand that as well?
Yes.
And that you're charged with trespassing and violating a city ordinance by having an open container. You understand that?
Yes.
You under the influence of any alcohol or drugs here today?
No.
You understand what you're doing?
Yes.
Think this is in your best interest?
Yes.
Okay, then I'm going to ask you how you'd like to plead to one count of trespass, guilty or no contest?
No contest.
And how about possession of an open container, guilty or no contest?
No contest.
I'll accept your pleas of no contest. I'll find your alert that you understand what you're doing. On count one, I'm going to adjudicate you guilty, sentence you to 10 days in the Broward County Jail. Credit for any time you have served on this case. On count two, adjudication, time served. You understand? I'm also going to direct that you not return to 4960 North Dixie Highway in Oakland Park. You understand that?
Yes.
That's a court order. You understand?
Yes, I understand.
They don't want you at that location. Okay?
Okay.
Good luck. Richard Hardwick.
He's here present, Judge?
Mr. Hardwick, you're here on a municipal ordinance violation for trespass. There's a capias or a warrant for your arrest. I do find probable cause. Bond is set in the amount of $100.
Can I explain something, Judge?
No, I don't want to talk about the facts of the case. If you'd like to resolve the case or end the case today, I could accept a plea from you of guilty or no contest. Otherwise, you need to see the judge who this case is assigned to.
I wish to resolve the case, but I want to explain that I went to court and the lady told me that that it wasn't a court date. I went down to the courthouse and she said it wasn't a court date, and she gave me some paperwork, but I don't have it with me to prove that I went down there.
Okay, I believe you, but how long have you been in jail now?
Ma'am,
How long have you been in jail right now?
right now I've been in there since yesterday.
Okay, if you want to plead guilty or no contest, I'll adjudicate you guilty and give you credit for time served.
Yes, ma'am.
Is that what you'd like to do?
Yes, ma'am.
You understand that you're charged with trespass on private property.
Yes, ma'am.
How would you like to plead, guilty or no contest?
No contest.
All right, I'll accept your plea of no contest. I'm going to adjudicate you guilty, sentence you to time served. Okay, this case is over, sir.
Yes, ma'am.
Okay, good luck to you. Robert Moore. Robert Moore.
Mr. Moore's here present as a name.
Robert Moore looks like he's scheduled to be released from the Department of Corrections tomorrow. This is a case where he's charged with a capias on a 2014 case. Bond is set in the amount of $500. It's a possession of drug paraphernalia. Would Mr. Moore like to resolve this case?
As a friend of the court, Mr. Moore did advise me he wishes to ask the court if you would consider resolving the case today for time served.
Mr. Moore, would you like to resolve this case today by way of a plea of guilty or no contest?
Yes, ma'am.
If you do so, I will give you credit for time served.
Yes, ma'am.
Okay, so as I told you, you're charged with possession of drug paraphernalia. That's a misdemeanor charge. It's punishable by up to, let's see, they have it as charged as a first-degree misdemeanor up to 1 year in the county jail. You understand that?
Yes, ma'am.
If you'd like to plead guilty or no contest, as I said, I'll adjudicate you guilty and give you credit for time served.
Yes, ma'am. I'd like to plead no contest.
Okay, I'll accept your plea of no contest to one count of possession of drug paraphernalia. I'll adjudicate you guilty of that and sentence you to time served. Good luck to you, sir.
Thank you.
Robert Bowman. Looks like Mr. Bowman's here on two separate capias. Actually, it's one case. It's a 2001 case. Bond is set in the amount of $500 on count one, $500 on count two, due to be released today from the Department of Corrections. Is that right, Mr. Bowman?
Yes, ma'am.
Okay. Unfortunately, I can't resolve this case today because it's a driving under the influence charge. You do need to see another judge on that case. But are you going to be living locally?
Palm Bay, ma'am.
Palm Bay, okay.
That's where my family is, my wife and kids.
You understand?
Children.
You understand that you have this pending driving under the influence charge here.
Yes, that was 17 years ago.
I understand, but it still needs to be resolved. You understand that?
I understand that.
So you're going to need to, if I release you on this capias or warrant, you're going to need to make sure that you get in touch with the clerk of court so that you know when your court date is. Are you going to be living on Gaskin Road in Palm Bay?
Yes, ma'am.
Okay, is it 2221?
Gascon Road, Palm Bay, Florida.
Okay. All right, on count one, I'm going to release you on your own recognizance. Count two, I'm going to release you on your own recognizance. I do find probable cause. You will need to get in touch with the clerk of court and appear on this case. You understand, sir?
Yes, I do, ma'am.
Okay, good luck to you.
Thank you, ma'am.
Calvin Johnson.
Johnson, come on up.
Mr. Johnson also looks like he's due to be released from the Department of Corrections today. Is that right, Mr. Johnson?
Yes, ma'am.
You're here today on a driving on a suspended license charge. It's from 2011. There's currently a $2,500 bond that was set by a previous judge. I do find probable cause. Are you going to be living here locally?
Yes, ma'am.
Let me just see for a second if I have a driving record on.
They are going to work in court.
Okay, Mr. Johnson, if you'd like to resolve this case today, I'm looking at your driving record. The driving record indicates that you have 2 suspensions out of Broward County for failure to pay, and once you pay those, your license would be reinstated. You understand that?
Yes, Your Honor.
If you'd like to plead guilty or no contest to this charge of driving on a suspended driver's license, it will count as a conviction for driving on a suspended license. If you get a combination of 3 of those in a 5-year period, the Department of Motor Vehicles will revoke your license for a period of 5 years. You understand that?
Yes, Your Honor.
Do you want to resolve this case today?
Yes, Your Honor.
Okay, how would you like to plead to driving on a suspended driver's license, guilty or no contest?
No contest.
I'll accept your plea of no contest. I'm going to withhold adjudication of guilt. I'm going to impose $293 in court costs, and I'm going to give you 6 months to pay that $293, okay?
Yes, Your Honor.
So you'll need to pay that and pay the couple of tickets that you have here in Broward, and then you can get your driver's license, okay?
Yes, Your Honor.
Good luck to
I'll
you.
be released.
Yes, sir. This case will be over with today.
All right, yes, Your Honor.
Good luck to you. Joshua Samuel. Mr. Samuel's here on a capias on a traffic case. It looks like he turned himself in on this. There's a $500 bond that was set by a previous judge. Looks like he's charged with driving on a suspended driver's license. I can't see which judge this is assigned to. Mr. Samuel, you live here locally?
Yes, ma'am.
It looks like this bond was set in the amount of $500 because you missed court. You understand that?
Yes, ma'am.
Because you turned yourself in, I'm inclined to release you, but I will tell you that I could take a plea from him today, but by looking at the driving record, it looks like he might qualify for the initiative program. So I'm going to release him on his own recognizance on this. But I'm going to tell you, Mr. Samuel, you need to see your judge on this case. You understand?
Yes, ma'am.
So I'm going to release you today. I do find probable cause. You need to find out from the clerk of court when this case is going to be scheduled, okay?
Yes, ma'am.
All right. Good luck to you.
I do see here on the docket that he's scheduled for June 5th. Is that the court date now deleted?
Well, you know, they schedule it because he's in custody, so you might give him that court date just so he can be double sure.
Okay, let me write it down.
Okay.
Right now, you have something, June 2017. You can call the clerk's office to confirm. And if they tell you to, you know you have court on that day.
Sometimes they delete it if it's not in custody, but that he needs to check on it, make sure. Okay?
Okay. That's fine.
Trenard Young.
Is here present, Judge?
Mr. Young, there's a capias or a warrant for a 2016 misdemeanor case, trespass on school grounds. It looks like there was a warrant for failure to appear. Want to take care of this case today? Does he have other matters?
No, Your Honor.
No? Want to take care of this case today?
Yes, ma'am.
If he wants to enter a plea, I'd withhold adjudication and impose $293 in court cost. Is that what you want to do, sir?
Okay.
Yes?
Yes, yes.
Okay. So I'm going to ask you then, how'd you like to plead to one count of trespass on school grounds, guilty or no contest?
No contest.
Okay, I'm going to withhold adjudication, impose $293 in court costs. I'm going to give you 6 months to pay that $293. You understand?
Yes, ma'am.
You need to pay that within the 6 months at the clerk of court, okay?
Yes, ma'am.
All right. Good luck to you, sir. Christian Jari.
Mr. Jari is here present, Judge?
Mr. Jari, you're charged with petty theft. I do find probable cause. Bond is set in the amount of $100. Would you like to resolve this case today?
Judge, he advised me that he plans on bonding out.
Okay, bond is $100. Good luck to you, sir.
Good luck, sir.
Kevin Puryear.
Mr. Puryear is approaching, Judge. He wishes to ask the court if you would consider resolving his case today.
Okay.
Mr. Puryear,
Yes, ma'am.
you're charged with obstructing a highway. You understand that?
Yes, ma'am.
If you'd like to resolve your case today, it would be an adjudication in 5 days in the county jail.
Okay, ma'am, I would like to resolve this today, and I would like to plead no contest.
Okay, so how would you like to plead to one count of obstructing a highway? Guilty or no contest?
No contest.
Okay, I'm going to adjudicate you guilty of obstructing the highway, sentence you to 5 days in the Broward County Jail, and give you credit for any time you have served on this. You understand?
Yes, ma'am.
Mr. Puryear, you understand that they don't want you standing out there on the street.
Yes, ma'am.
It's a violation of the law. You understand that?
Yes, ma'am.
Okay, good luck to you, sir.
Thank you, ma'am.
Herbie Crussell.
Yes, ma'am. Hello, ma'am.
Morning, Mr. Crussell. You're charged with municipal city ordinance violations, soliciting in the street, and another municipal ordinance violation, no OSHA safety vests.
Yes, ma'am.
You understand that?
Yes, ma'am.
You're alleged to have been standing, soliciting for money on the corner of Atlantic Boulevard and I-95. You understand that?
Yes, ma'am.
If you'd like to resolve your case today, I would adjudicate you guilty and sentence you to 5 days in the county jail with credit for any time you have. Is that what you'd like to do?
Yes, ma'am.
How would you like to plead, guilty or no contest, to soliciting in a street and no OSHA safety vest? Guilty or no contest?
No contest.
Okay, I'll accept your plea of no contest, Mr. Crushel. I'm going to adjudicate you guilty as to each count, sentence you to 5 days in the Broward County Jail. Credit for any time you have served. You understand you cannot stand on the corner of Atlantic and I-95.
I do, ma'am.
That's a violation of a municipal ordinance to do so. You understand that?
Yes, ma'am. Yes, ma'am.
Okay, I'm going to direct that you not return to that location, okay?
Okay.
Good luck to you, sir.
Thank you.
Pardon? Yes, they are. Franklin Blumberg.
Mr. Blumberg is approaching, Judge.
Mr. Blumberg is charged with possession of cannabis, 20 grams or less. I do find probable cause. There's a $100 bond set on that amount. It's also here on a capias on a misdemeanor charge where bond is set in the amount of $500. I find probable cause to that as well.
Judge, Mr. Blumberg is asking if you would consider an ROR on both counts. My understanding is, from what he advised me, he was homeless at the time, and that's why he never got notice. Right now, he is living with his godmother, who lives in Tamarack. So now he has an address he'll be able to receive notice. That's why he's requesting you consider ROR on his behalf.
Okay, well, the address that he gave when he was arrested is in Oakland Park, not in Tamarack. So bond is set in the amount of $600 total on both of these. I do find probable cause.
I just moved in. I didn't know the address.
Judge, he's advised me he didn't know the address.
I understand, but he needs to see the other judge where he didn't appear. That's the $500 bond.
Yes, Judge.
Zachary Alexander King.
I've been advised he bonded.
I find probable cause. Kenneth Alexander Jennings.
Mr. Jennings declined to serve as public defender. Good morning.
Good morning, Mr. Jennings. You're here on, looks like, 3 separate cases where capiases or warrants were issued for you from other judges. Bond is set in the amount of count 1, $2,000, count 2, $2,000, count 3, $2,000, and count 4, $2,000.
Your Honor, I was asked if I can have the bonds reduced only because of my situation with me being the sole provider of my family. I have 3 kids. I just got married, and I'm an independent business owner. I'm a painter, and if I don't work, I don't get paid. And I would just ask if I can have the bonds reduced so I can provide for my family.
It looks like these capias were issued by another judge because you failed to appear in court on a number of occasions.
Yeah, I wasn't received the notification for appearing at court.
What's your address now, sir?
1321 Northwest 50th Avenue. I just have notice for the post office that I was getting my mail sent to my old address where I was currently staying for 10 years in Oakland Park. And now I'm staying at my residence now, which I have all my information changed to. And I've been staying there for just over a year and a half.
Okay, on count 1, I'm going to reduce the bond to $250. On count 2, I'm going to reduce it to $250. Count 3, $250, and count 4, $250. So a total bond of $1,000, sir.
Thank you, Your Honor.
I do find probable cause. Zayad Mirza.
Mr. Mirza?
Mr. Mirza is here on a violation of probation on a driving under the influence charge. He needs to see Judge Lerner Wren. He's being held on a $500 bond. I do find probable cause. There's a court date scheduled for June the 5th at 2 o'clock in the afternoon.
Thank you, Judge.
Leonardo DeCosta.
Mr. DeCosta is here present, Judge of Maine.
Mr. DeCosta is charged with possession of cannabis 20 grams or less, license not carried or exhibited, and a tag unsecured. Bond is set in the amount of $100 on count 1. I do find probable cause.
Judge, Mr. DeCosta is 19 years old. He advised me this is his first arrest, so he may be eligible for a diversion program regarding this incident. I'd ask you, since it's a nonviolent offense, to ROR Mr. DeCosta. He is going to college. He goes to Palm Beach State. He lives in Deerfield.
Is the address on 8th Avenue?
Yes, ma'am.
Does he have any priors? Pardon?
No.
Okay. Okay, on count 1, I'm going to release him on his own recognizance. Mr. DeCosta, it's your responsibility to find out when your court date is and appear in court. You understand?
Yes, ma'am.
Okay, I'll release him on his own recognizance. I do find probable cause.
Good luck, sir.
David Perez.
Perez, Judge, you need to find service public defender.
Mr. Perez is charged with 1 count of grand theft auto. I do find probable cause, and bond is set in the amount of $1,000. Chris Banks.
Mr. Banks is here present, Judge. He declined the services of public defender.
Mr. Banks, good morning. You're here on counts 3, 4, 5, and 6, violation of probation. It looks like case number 150-10709. Being held no bond. You need to see Judge Kalra. You're scheduled to see Judge Kalra on June the 5th at 9:45 in the morning. I do find probable cause.
Alrighty.
Demetrius Wilson.
Judge, I've been advised Mr. Wilson was transported to court. I don't know for what matter.
Transported to court?
Regular court, correct.
Okay, well, he needs to be magistrated on these counts, so I'm going to reset it. Want to reset it for tomorrow or for 1:30?
We can try and do it today, 1:30.
Okay, we'll reset till 1:30 today.
Wilson?
Demetrius Wilson.
17? He's in regular court. Yeah, I Right. All right.
Reese-
If he's back, they're gonna bring him.
Okay, thank you.
Thank-
Whoops. We reset it for 1:30. Teal Morosini.
He's here, President Maine.
Good morning. Mr. Morosini is charged with criminal mischief over $1,000. I do find probable cause. Bond is set in the amount of $500.
Judge, respectfully and speaking, Mr. Marcini, 58 years old. He did advise me financially he has no one to post his bond, but he has a place that valid address. Judge, we'd be asking you to consider pretrial release on Mr. Marcini's behalf.
That's denied. Mr. Morosini has a $500 bond.
Yes, Judge.
Shaquille Kareem Granau. I think Mr. Granau has a violation of probation on case number 1301350 CF10A. He's being held no bond. Need to see your judge on your violation of probation is scheduled for June the 6th at 8:30 in the morning. I do find probable cause. Valerie Podolski.
He's here, President Maine.
Pardon? So not for, oh, it says not for magistrate. So he's not, we just need to delete him? Yeah. Okay. He's deleted, it's not for magistrate. Pardon?
What about count 4?
What about it?
On the docket, it shows that all the other counts are not for magistrate, but it doesn't have the same denotation for count 4.
But if you look at count 4, it's a violation of a court order.
Yes, it is. It's a no bond hold like the others, but it doesn't indicate that it's not for magistrate.
And that's why he was brought here today.
Okay, that was done in error? Okay.
Yeah, he needs to see the judge on the violation of the court order. So we're going to delete that one. Watley Nordellis.
Mr. Nordellis here, President Judge of Maine.
Mr. Nordellis is charged with petty theft, second degree, first offense. He's also charged with possession of cocaine. I do find probable cause. Bond is set in the amount of $1,000.
Thank you, Judge.
John Orubo. Mr. Aruba is charged with grand theft, unlawful possession of personal ID of another. Count 3, unlawful possession of personal ID of another. Count 4, obtaining property under $2,000 by fraud. Count 5, passing a false or falsely embossed or altered credit card. And 6, passing a forged, falsely embossed or altered credit card. State wish to be heard?
Yes, Your Honor. He is here illegally, according to NCIC. And if the court's inclined to set a bond, we'd ask for a no bond under the fact he's here illegally. There's a possibility of a detainer being lodged as we speak. It has not been done yet. I got to be honest with the court about that. I would ask that the passport be surrendered. The next person up is also a co-defendant in this somewhat same situation. I'm not sure of his status about illegally being here. Mr. Ola, who's probably next on the docket.
Okay, let's talk about Mr. Arubo first. Okay. Mr. Arubo, the bond was already set as far as the standard bonds. On count 1, it was $1,000. On count 2, it was $100. Count 3, $100. Count 4, $5,000. Count 5, $1,000, and count 6, $1,000. You want to speak to the bond?
Well, I think once the detainer's lodged, it's somewhat of a moot point, but yes, the police are concerned about the flight risk. And in this particular case, no pun intended, because this happened at the airport, but they are concerned about a flight risk.
Okay, so bond right now is set in the amount of $8,200 total. And defense, you have anything?
Yeah, Judge, in speaking with Mr. Aruba, he did inform me that he's actually from Massachusetts. That's where he's living and that's where he works. He works at the Intercontinental Hotel. He's an auditor. He's been working there for about 3 years. His birthplace is Nigeria. He did advise me, though, he is a permanent resident here in the United States. Judge, we'd be having standard bonds in place at this time.
Well, the address that it looks like is on this arrest sheet is in, it looks like Minnesota.
He has other priors, Your Honor. He has New Jersey priors.
For?
Prior similar related crimes, Your Honor.
Yeah.
Where?
Out of New Jersey and New York.
When you say similar related, can you tell me what they are?
Yes, Your Honor. Credit card theft. Out of New Jersey, 2010. He also had receiving stolen property. That was also out of New Jersey, New York. Forgery. Credit card, forgery of a credit card, Your Honor, out of New York, 2009.
Okay, on count one, I'm going to increase the bond to $5,000. On count two, the bond will stay where it is, $100. Count three, $100. Count four is $5,000. On count five, increase the bond to $5,000. And count six, it's $1,000. The total bond would be $16,200. If he's released on bond, he must before he's released on bond, he must surrender his passport to the clerk of court. I do find probable cause as to all counts. Bolangio Ola.
Judge, would you consider, as far as the condition with the passport, would you consider upon his release within 48 hours he would have to surrender his passport to the clerk's office?
No, he needs to surrender his passport before he gets released. Bolangio Ola. Mr. Ola is charged with grand theft, also charged with larceny of a credit card and obtaining property under $2,000 by fraud. I do find probable cause as to each of those counts. State wish to be heard?
Yes, Your Honor. He also is a citizen of Nigeria. We'd ask for the surrender of the passport prior to posting of any bond.
Defense?
Judge, my understanding is he's from New Jersey. He was here on vacation Memorial Day weekend. He's currently employed in New Jersey. He works for Hog Motors. He's a sales rep. He says he's been in the United States for practically his whole life. Judge, I'd ask you at this time just keep these standard bonds in place.
Yeah, on count one, I'm going to increase the bond to $5,000. On count two, the bond is $100, and on count three, the bond is $5,000. As a condition of his release, he must surrender his passport to the clerk of court. Total bond is $10,100. I do find probable cause. Joseph Yeshua?
Mr. Yeshua is here present, Judge. He's declined to serve as public defender.
Mr. Yeshua is charged with robbery with a firearm and count 2, wearing a mask while committing a second-degree felony. As to count one,
Actually, Judge,
what?
he changed his mind. He did sign up with the public defender.
Okay, so count 1, I do find probable cause. On count 2, I do find probable cause. On count 1, I also find that proof is evident and presumption is great. He'll be held no bond on that until he can see his judge for a bond hearing in that matter. On count 2, I'm going to set bond in the amount of $10,000.
Our position would be, Judge, that we'd ask the court to conduct an Arthur hearing at this time and make a finding based on the probable cause affidavit that the state has failed to meet their burden of proof being evident and presumption great, that being a higher standard than proof beyond a reasonable doubt. That argument is made pursuant to the Florida Constitution and State v. Arthur.
Okay, I've made my
We would ask you to
findings.
set a bond for Mr. Yeshua.
Okay, I made my findings with regard to that. I note your argument for the record. Mark Rutledge.
Mr. Ruffledge, come on up, please. 21. He was deleted off the docket as well. Judge, I didn't.
It was deleted off the docket because it's the same situation, right? Not for men. Pardon? Okay. So this is a court order rather than, okay. So I'm going to delete this. Cashfroy Francis McKenzie. Mr. McKenzie's charged with grand theft auto and resisting an officer without violence. I do find probable cause as to each count. Bond on count 1 is set in the amount of $1,000.
Thank you, Judge.
Dondre Montac.
Mr. Montac declined to serve as public defender.
Mr. Montac's here on a violation of probation or community control in case number 15010525 CF10A. You're being held no bond on that violation of probation. You'll need to see the judge who you're on probation with. That's scheduled for June the 6th at 9 o'clock in the morning. I do find probable cause. Jeffrey Eggemeyer.
We waive formal reading of the charge.
Says hold for South Bay.
Judge,
Delete this one too?
I'm being advised, but he was deleted from the docket per confinement status.
Right. We're deleting it from the docket. Michael Anthony Koya.
He's here, present, Judge. He declined to serve as public
Mr.
defender.
Koya, you're charged with grand theft. I do find probable cause. Bond is scheduled and set in the amount of $1,000.
Okay.
Roderick Renard Edwards.
Mr. Edwards is here, present, Judge of Maine.
Mr. Edwards is charged with aggravated battery and aggravated child abuse. Bond has already been set in these. I do find probable cause. Bond was set on count 1 in the amount of $25,000. Count 2, $25,000.
Judge, if the defense could be heard regarding bond, Mr. Edwards has been residing in South Florida his whole life. He's 27 years old. He's currently employed. He works for a company called Advanced Roofing. He's been with the same company now for about 7 years, making approximately $17 an hour. He will be living separate and apart from the victims. He'll be residing with his mother, who resides in Fort Lauderdale. Judge, we'd be asking you to, at this time, consider reducing the bond on count 1 to $10,000 and reducing the bond on count 2 to $10,000. His mother will be the only person that would post his bond. He thinks that something that he'd be able to come up with, he's not sure. Financially, he has no money in the bank, no property, and that's why we were making that request, Judge.
Okay, Mr. Edwards was arrested pursuant to a warrant to arrest, and Judge Cholera scheduled the bond on that warrant at $25,000 per count. So whoever the case is assigned to, he'll need to see with regard to addressing any bond issues. I do find probable cause.
Actually, Judge, the defense's position would be that's a convenience bond. The purpose of that bond is for him, in order to go ahead and forego his right to be magistrated, he could elect to post that bond. At this time, he cannot afford to post that bond. That's why he's still here, and that's why at this time, you're the magistrate judge, you have the discretion of modifying it pursuant to his ties to community's financial resources. That's why we're asking you to actually reduce it to $10,000 each count.
I understand I have the discretion. I'm going to decline to use that discretion this morning, and you can see the judge whose the case is assigned to.
Yes, Judge. What judge is it?
I don't know. You have to ask your attorney there. Alberto Lugo.
Mr. Lugo, come on up, please.
Mr. Lugo is charged with 4 separate counts of battery on an officer, firefighter, EMT. Counts 1, 2, 3, and 4. I do find probable cause. The state wish to be heard?
Lugo, L-U-G-O.
One moment, Your Honor.
Alberto Lugo.
What's the bond on it right now? No.
Says hold for magistrate.
He has a 2006 of resisting without violence. DWLS. I don't see anything else, Your Honor.
Okay. Defense?
Judge, in seeing Mr. Lugo, he's been residing here for the past 20 years. He is 31 years old. At this time, he collects disability. He gets approximately $800 per month. He lives in Tamarack with his mother. They've been renting the same apartment for the past 3 years. Judge, from what he knows, the monthly rent on the apartment is $1,400 a month. He relies on his mom for financial support. We'd be asking you to take that into consideration in determining a reasonable bond on Mr. Lugo's behalf on counts 1 through 4.
Mr. Lugo taking his medication? Is Mr. Lugo taking his medication?
That I cannot answer.
Pardon?
Yes, he's advising me that he is taking medication. I take.
Okay, and do you know whether his mother wants him to come back and live at that residence?
My understanding is Mr. Lugo has advised me that he's still welcomed at his mother's place and that she's actually waiting on him.
Okay, State?
Excuse me. I draw your attention to the middle paragraph of the last page of the PC regarding setting a bond. Maybe the first 3 counts, reasonable bond of less than a standard bond, although one count when he actually struck a police officer with his fist would justify a standard bond, at least in that count.
Okay, on count 1, a set bond in the amount of $2,500. On counts 2, 3, and 4, I'm going to release him on his own recognizance. As a condition of his bond, he's going to be supervised by pretrial release. He needs to call pretrial release 3 times a week. And he needs to take any prescribed medication. Who's his treating doctor? Is it through any local agency?
Judge, my understanding is he has his own doctor, Mr.
A private doctor?
Correct.
Okay, you need to follow through with your doctor and take any medication that you're supposed to be taking. You understand, sir?
Yes, ma'am.
Okay, and you need to contact pretrial release and call them 3 times a week so that they can check on you, okay?
Okay.
All right, good luck to you, sir. I do find probable cause as to each count.
Once you find out this location of pretrial at the map, see the line? You have to go across the street and actually report to pretrial as soon as someone can post this monetary bond, okay? Good luck to you.
Zayn Henry.
Mr. Henry.
Mr. Henry is charged with one count of grand theft. Count 2 is fraud, use or possession of an ID of another person without consent. Count 3, possession or receiving, retaining a stolen credit card. Count 4, illegal use of a credit card more than 2 times in 6 months, goods over $100. Count 5, illegal use of a credit card more than 2 times in 6 months, goods over $100. 6, illegal use of a credit card 2 times in 6 months, goods over $100. Count 7, illegal use of a credit card more 2 times in 6 months, goods over $100. And count 8, fraudulent cash deposit bank item with intent to defraud. I do find probable cause as to each of those counts. Anybody wish to be heard?
Judge, in light of the fact that he's being held no bond at this time, I'd ask that the regular bonds be left in place and let him go in front of Judge Bailey on June 5th.
What's he being held no bond on?
This is Mr. Henry.
Yes.
I have a count 11 violation of probation on case number 1501046 CF10A.
State.
I mean, it's right here on the docket.
It's just not on the sheet before me, because he's being held. You're saying he's being held on a violation of probation.
That's what my docket shows.
Okay. I do find probable cause as to each of these counts. On each of the counts, 1 through 8, bond is set in the amount of $1,000. $8,000 total bond. I don't have a.
It's possible the docket could be wrong.
Oh, wait, I'm sorry.
Yeah,
I'm sorry.
We have it.
Count 9 and count 10 and count 11. You're right, Mr. Reedy, thank you. On count 11, he's being held no bond on a violation of community control on a felony. On counts 9 and 10, the bond's also set at $1,000. I find probable cause as to all counts. So it's $10,000 total on the pending cases and no bond on the violation of probation. Thank you, Mr. Reedy.
You're welcome, Judge.
Stevie Spicy.
Mr. Spicy, Mr. President, Judge of Maine, Mr. Spicy, come on up. Judge, we're going to be requesting a photo order.
Okay. Mr. Spicy's charged in count 1 with resisting an officer without violence. He's also charged with a probation violation on a felony charge, being held no bond on that. I do find probable cause. On count 1, the bond is $100. On count 2, there's no bond. He's scheduled to see his judge on that case on June the 6th at 8:30 in the morning. And I will sign an order to take photographs.
Thank you, Judge.
Max Mazard.
I've been advised Mr. Mazard bonded, Judge.
Okay. I do find probable cause as to each count. Emilio Gordon Smith. Is this Mr. Gordon Smith? Is this Mr. Gordon Smith?
Yes.
Mr. Gordon Smith charged with carrying a concealed firearm in count 1, charged with possession of cannabis 20 grams or less. Also charged in count 3 with possession of paraphernalia. Count 4, driving while license suspended, and count 5 is a seatbelt violation, traffic infraction. I do find probable cause as to each count. On count 1, bond is set in the amount of $1,000.
Thank you, Judge.
Shantonio Gibson.
Mr. Gibson is here present, Judge of Maine. He's the Fine Service Public Defender.
Mr. Gibson is charged with aggravated assault with a deadly weapon without intent to kill. I do find probable cause. Any priors on Mr. Gibson?
Judge, I believe he changed his mind. He wants to apply with the public defender.
Okay. Mr. Gibson, don't say anything about your case. You have an attorney standing there next to you. Okay.
Had priors, Your Honor, but they were dropped.
Okay.
Let me just see if anything else.
Defense?
Judge, my understanding Weinstein, Mr. Gibson. He's 40 years old. He's been residing in South Florida since roughly about 2005. Self-employed. He does about landscaping. He's been doing that for about 6 years, and it averages as far as how much he gets paid. He lives with his parents. His parents, from what he advised me, they're elderly and financially they can't really afford to post that high of a bond. Respectfully, we'd be asked to impose a bond of about $1,500 on Mr. Gibson's behalf.
I would just add, Judge, that the knife involved here was approximately 3 inches in length, which is possible it doesn't qualify even as a deadly weapon. And the victim was 30 to 40 feet away. So there was quite a distance between the two individuals when this incident happened. I'm not saying that there isn't probable cause to find an aggravated assault, but I think it's pretty weak.
Okay, well, I do find probable cause. My concern is where is Mr. Gibson going to reside with his parents? Is that in Pembroke Pines? Yes.
Correct.
Hang on 1 second, sorry.
Mr. Gibson appears to be wanted out of Virginia Beach, Virginia. Warrant was issued May 28th, 2015 for contempt of court. And
Okay.
it appears to be still pending, Your Honor.
Okay.
I believe that's a child support matter, but the one issue I wanted to address with the court is, I believe the alleged victim in question is a neighbor that lives on the same block, about 6 houses down. He intends to still reside with his parents. I did inform him that there would be a no contact order, so he couldn't have any sort of contact. I believe it might be. I don't know if Your Honor is going to be imposing a foot requirement, but that's why I wanted to be candid with the court and just let you know he lives about 6 houses down.
Right, I see that it's, unfortunately, that it's a close proximity neighbor, so that's my concern. I'm going to set bond in the amount of $5,000. I do find probable cause, and I'm going to order as a condition of that bond that there be no contact, indirect or direct, with the alleged victim in this case, which is Brent Houghton. And I'm going to direct that Mr. Gibson stay at least 500 feet away from Mr. Houghton and his property, which is located in Pembroke Pines as well on Southwest 4th Court. You understand that, Mr. Gibson?
Yes, ma'am. Judge, the only thing that he advised me when I told him typically the standard foot requirement is about 500 feet, he thought that would be in violation as far as where his house is and the alleged victims. Would you reduce it to 200 feet?
No, it's going to be It's going to be 500 feet. If Mr. Gibson gets out of jail and finds out that his house is within 500 feet of that house, he can bring it to the attention of his attorney, and you can address it with the court. But the court order is that he stay 500 feet away from that gentleman and or his property, and he'd have no contact, direct or indirect, with that gentleman. You understand, Mr. Gibson? Okay. Christian Gabriel.
Mr. Gabriel is approaching, Judge. He's declining the service of public defender.
Mr. Gabriel's charged with distributing or delivering cocaine in count 1, distributing or delivering cannabis in count 2, trafficking in cocaine 26 grams or less than 200 grams, trafficking in cocaine 20 grams and less than 200 grams, and possession with intent to sell, manufacture, or deliver cocaine. I do find probable cause as to each of those counts. Count 1, bond is set in the amount of $2,500. Count 2, bond is set in the amount of $1,000. Count 3, bond is set in the amount of $15,000. Count 4, bond is set in the amount of $15,000. And count 5, bond is set in the amount of $2,500.
It's Kim.
Clinton Coleman. Mr. Coleman is charged with driving on a suspended driver's license as a habitual offender. He's also charged with leaving the scene of a crash involving damage to property, Count 2 and Count 3, leaving the scene of a crash involving damage to property. Count 4, failure to use due care, and Count 5, failure to use due care. Bond is set in the amount of $750. I do find probable cause.
Thanks, Judge.
Jonathan Castillo.
Judge, I've been advised Mr. Castillo bonded.
I do find probable cause in Count 1 and Count 2 against Jonathan Castillo. Michael Deladoni.
Mr. Deladoni is approaching, Judge. He declined to service as a public defender.
Mr. Deladoni is charged with aggravated assault with a deadly weapon without intent to kill. I do find probable cause. Anybody wish to be heard? Don't say anything about your case, Mr. Deladoni.
Okay.
I see a.
Pardon?
I see a trafficking with trafficking cocaine, 1987. Resisting without violence. End of priors, Your Honor.
Okay. I do find probable cause. I'm going to set bond in the amount of $10,000 on the Count 1, no contact with Randolph Joseph Robinson. And you're not permitted to go within 500 feet of Randolph Joseph Robinson and or his property. You understand, Mr. Deladoni?
Yes, ma'am.
Okay. Don't say anything about your case.
Okay. Judge, I believe, as a friend of the court, his concern is, I believe, in reference to the no contact the foot requirement. I believe his home is located within close proximity of the alleged victim.
I see that, and that means he's going to have to be somewhere else if he makes bond until he gets this straightened out. Silas Whitehead.
Judge, Mr. Deladoni is asking, he didn't hear how much the bond the court said. And
$10,000 bond.
Yes, Judge.
Mr. Whitehead is charged with aggravated fleeing with injury or damage, operating without a valid driver's license, commit grand theft or use a vehicle, damage property, and robbery, no firearm or weapon. I do find probable cause. Does anybody want to be heard?
He has no adult priors, but he does have juvenile priors, Your Honor.
What are his juvenile priors?
You have to go on sidebar to.
Pardon?
You have to go on sidebar, I believe, if you want to hear the.
Okay.
2014 burglary structure. 2014. Burglary structure unoccupied with a resisting without violence. 2013 strong arm robbery. 2011 burglary unoccupied structure. 2010 burglary conveyance unoccupied. I have other priors of this decision.
In any way involved in that strong arm robbery?
Well, there's another probable cause affidavit
Yes.
saying the vehicle was stolen during an occupied residential burglary at 215 Southwest 3rd Street in the city of Pompano Beach.
Oh, I don't see that in here.
That's a separate probable cause affidavit.
Oh, okay. All right. I don't have it.
So that's why I found probable cause as to each count. As
Okay.
to,
So there's a separate probable cause affidavit dealing specifically with the strong arm robbery?
yes, and it alleges
Okay.
that the vehicle had been stolen during an occupied residential burglary, that the victim does not know the defendant, and he did not give the defendant permission to take possession of his vehicle, and the victim indicated that he would prefer charges against the defendant and completed a theft affidavit.
Okay.
Okay? So on count one,
Judge?
yes.
In speaking, Mr. Whitehead, he advised me, he's 18 years old, he's been residing here his whole life, he's looking for work at this time, he's unemployed, he has no money in the bank, no property, he lives in Pompano with his mother. His mother is the only person that can potentially bond him out. However, from what Mr. Whitehead indicated, right now she's financially indigent. She has 16 children, and right now she cannot possibly afford any sort of bond. What he's requesting, Judge, is if you would consider pretrial release, level 1 house arrest.
Okay, on count one, I do find probable cause as to all counts. On count one, I'm going to set bond in the amount of $5,000. On count three, bond is set in the amount of $7,500. And on count four, robbery with no firearm or weapon, I'm setting bond in the amount of $10,000. I do find probable cause. Trent Sessoms.
Mr. Sessom, sincere present Judge Germain.
Mr. Sessoms is charged with grand theft. I do find probable cause. Bond is set in the amount of $1,000.
Yes, sir.
I don't know.
Any other matters?
Your Honor, there is one that I don't know if it's on the docket. Dennis Patterson, apparently it's a carryover from yesterday.
Correction?
It's on page 29,
Dennis Patterson.
but I don't see anybody over there.
Judge, I've been informed he's in regular court.
Okay, looks like there was a probable cause finding on count two, touch or strike, battery, dating, violence by Judge Zeller. On
No, it says OPC.
And then it looks like there was a no probable cause finding on count one. And it was reset for today. You want to set it for 1:30?
That's fine, Your Honor.
Want to set it for 1:30?
Reset for the PM?
Is that okay with you? Can you hear us or not?
No, I can't. I'm just.
I mean, it was reset because there was no probable cause finding on count one.
At this time, do you know if the state brought in any additional information?
Yes, I have a new police report.
Yes.
Oh, well then, yeah, we can reset it for 1:30.
Okay, so we'll reset it for 1:30.
Thank you, Judge.
Anything else? They're indicating that you might be done with that program in June. Is that right?
Yes, ma'am.
Okay. So page 3, I have it. This is Ashley Rodriguez Serrano.
Yes.
Is that right? Okay, so I'm going to give you, it says that they're going to be done by June 14th. So I'm going to give you a date after that date so that June the 29th. Okay, can we give her a notice for that? At 9 o'clock in the morning in my courtroom, in my regular courtroom. I appreciate your patience here this morning. And we'll see you on the 29th, assuming you're finished with the program, then they'll null process or dismiss your case on that day, okay?
Okay, no
All
problem.
right,
Thank
thank
you.
you very much. That's okay. Serrano.